Hello students, today we would like to examine the criminal justice administration aspects of our country, with primarily the focus will be on the punishment system and also on the prison jurisprudence as it has evolved in India over a period of time. Now friends, to begin with, what is it that the criminal justice system of our country seeks to achieve? Well, it would not be an exaggeration if we say that the purpose of a criminal justice system at the end of the day is to establish peace. If we take a look at the theories proposed by some of the very established criminologists, scholars like Bentham, we look at the theories of Beccaria, James Mill, these authors have tried to convey only one important thing, that the law must be upheld in any valid legal system under any circumstance, and the criminal justice system should be so geared that it is able to take care of the concerns of the peace establishment in the society. Now, what aids the implementation of the criminal justice system in the countries? The answer is very simple. It is the laws and the manner and the content of the law defines and ensures that how successful the implementation process is going to be. So in this respect, we would like to focus on the provisions of the Indian Penal Code of 1860. We would also look at the aspects of Criminal Procedure Code as it is contained under the Code of Criminal Procedure Act of 1973. We would also be taking care of some of the committee reports, important committee reports, which have come out from the Government of India, that mainly brought out by the Ministry of Home Affairs. And we'll also take care of some independent reports from time to time which have come up. Since we are trying to have a broad based understanding of the implementation of the law with respect to criminal justice administration of a country, we would like to focus at very fine aspects of the criminal justice administration. Now friend, these three words carry very specific meaning to begin with. Criminal justice administration. Now, what is criminal? Okay, I believe today if we are sitting here and trying to understand what is wrong with the world, and we try to understand as to why crime is surging in the society, you just need to take a look at the National Crime Records Bureau report of India of year 2017 and 18. For 19, I believe it has not come up yet. For the year 2017 and 18, Ministry of Home Affairs released in one go. There was a gap of 1 year. And in these reports, if you look at the data, the reports are divided. They take stock of the offences committed during the whole calendar year in the country, and the listing and the categorization of the offence is as per the Indian Penal Code. So you have offences like murder, rape, dacoity, etc. listed, and then you have also a categorization done over there which takes care of these crimes or offences committed under special and local laws, SLL. So the category of special and local laws takes care of offences like, let's say, some like offences of socio-economic in nature. Like these offences are characterized by their socio-economic orientation, and it's not very hard to contemplate the scheme of such offences. For example, if a Dalit in the society, that is a person who belongs to scheduled caste. So Dalit is a term which is a media invented term, and officially, for official purposes, the categorization is of scheduled caste. That is the category which is there. So now the offences committed against scheduled caste or a scheduled tribe will be taken care of under the Atrocities Act of 1989. That is Prevention of Atrocities Act against Scheduled Castes and Scheduled Tribes of 1989. So there will be certain offences listed there, that if someone insults the member of that community in certain manner, then there are punishment prescribed. So, but that's the purpose of that legislation is special. It is one, welfare oriented. Two, it aims to bring speedy justice with very special category of crimes in the society. Then similarly, you have Food Adulteration Act. You may have also take a look at the Dowry Prohibition Act. You may also take a look at the Protection of Women from Domestic Violence Act of year 2005. So again, there women are categorized and understood as a vulnerable community in our society. And the Prevention of Domestic Violence Act aims to give them relief under certain circumstances. That is, whenever they come under assault or they feel that they are violated due to some reason or the other. So the court may grant them protection orders. They also pass residence orders, etc. under that particular act. Now, friends, you must understand that the whole object of the criminal justice system progresses on the basis of the task performed by some very important components which are there in this whole system of criminal justice administration. Now, who could be these persons? These persons are police, prosecution, members of the judiciary, civil society also, and we have seen in cases like the Jessica Lal murder case, Nitish Katara murder case, and many more such famous cases which became very popular in media as you could say star cases, or where the concept of media trial emerged, that, and which basically implies that the media is proactive almost 24/7 and following up that case, and is dissecting that case on air, while on the news channel when it is being broadcasted. So the idea is that we have to understand that these actors do their duties, perform their responsibility as stipulated and as it is expected from them. Unless and until that happens, you see the criminal justice system may not function well. So if it is like a wheel, okay, so the wheel moves, so there are different cogs in the wheel. So if one cog is removed, you remove one spoke, some effect it impairs the movement. Then you remove one more spoke. Then there comes a time when there is no spoke in the wheel. So what will happen? So it is not difficult to imagine that it might crash, or most likely it will crash. So the idea is that the role of civil society is also very important. And if we say that we want to have a very broad-based understanding of the criminal justice administration in India, we want to have a comprehensive understanding, then we cannot ignore the role which is performed by all these agencies. And friends, the role performed by the police is very important in the country. Like, police is the primary investigating agency of the country and is the first agency to come in contact after a crime is committed, whether a complaint is lodged with the police in the form of an FIR, First Information Report, under section 154 of the Code of Criminal Procedure Act of 1973, or some other private person who is aware of the commission of an offence may also go and report to the police that at X place at a certain time this particular offence was committed and he or she witnessed the commission of this crime. The idea is that the law has to take cognizance of the commission of the crime. Now, it may be said here before I start talking more about the aspect of the punishment, and which is taken care of mainly from section 53 onwards in the Indian Penal Code of 1860, and also talking about the sentencing policy, because only then we can properly understand as to why, how the prison system in India is organized. So before going into that, let me just make one thing very clear for your understanding, and that is that at the foundation of the criminal justice system, the idea prevails. The idea prevails that the force can only be used by the state. All right. Why state uses force and how it uses force? State employs force through the agency of police, through its police arm. Okay, so police is vested with a twin responsibility, twin leading responsibility. One, it has to ensure peace and order in the society, and second, it has to investigate and do proper investigation as laid down in the law to make sure that the offender or the person who has committed a particular crime is brought to book. When I say brought to book, it simply means that the person should be answerable to the law. And how is he made answerable to the law? That their case may be registered against that person, and then upon investigation, if it is found that the person had a complicity in the commission of that particular offence, he may be arrested after and under execution of an arrest warrant as issued by a competent authority under law. That person may be brought before a magistrate of first class, and then the trial process may begin. Trial process begins only after a challan or a charge sheet is filed under section 173 of the Code of Criminal Procedure Act of year 1973. So that is the aspect of how the train of criminal justice administration moves. Friends, it is very important for us to understand at this point of time that there are different stages in the commission of the crime, and crime is not a crime unless there are two things in basic criminal law understanding do not coalesce or come together, and these two things are known as actus reus and mens rea. So mens rea is the mental element of criminal law, and actus reus is the active commission part. For example, if we say that Dawood Ibrahim, okay, I am using this example because it is well known if you are reading the newspapers and the reports that he is an absconder and he is a wanted person, and Interpol that coroner notice has been issued against him, and he is a declared terrorist, we know. So the police, there are several cases filed against him, and he is a wanted man under not only the national laws but also under the international law. So now let's say he is sitting somewhere outside the country and he is planning to execute a terrorist attack where he employs many persons who are being given direction by him, and he asks them, okay, you have to go to X place and then you have to commit crime in this manner, like the manner in which the crimes were carried out in the Bombay attacks case, Mumbai attacks, where you know that there were several terrorists, and prominently Mir Mohammad Ajmal Kasab was arrested in that case alive. He was put on trial and then ultimately he was hanged. So this is the case history is pretty much well known for almost every person who is keeping track of the criminal developments in the country. So as someone who is very closely interacting with law, so you would need to look at such cases. Now the point is that the Dawood Ibrahim is very much guilty of committing such offences because the intent is there, and that malice which is there in him, that is transferred in the people who committed with the intention. So he is also equally responsible, let's say, if the directions came from him as per the investigation. Alright, so now the idea what I am trying to simply convey to is that there is a chain of in the commission of crime. Similarly, once the crime is committed, there is a stepwise progression towards the delivery of justice, which would basically be in the form of either an acquittal or it would be in the form of a conviction of the accused person. So there is an accused person at the center of the trial, all right, and there are several charges which are framed against that accused person. The police submits the charge sheet, it draws up certain charges, and evidence is placed by the prosecutor before the court of law under the various provisions of this Criminal Procedure Act. And we will have occasion to look at several of these particular points as we go along in our meetings. So now you must understand that there is a progression, clear-cut stage-wise progression towards the ultimate delivery of justice, which results either in acquittal or the conviction of the accused person. And the substantial aspect of justice delivery rests on the evidence which is tendered in a court of law by the prosecutor, and also whatever is submitted by the defense counsel would also have relevance with regard to the testimonies which are placed before the court of law. So this is very important for us to understand. And the role of the police, the prosecutor becomes very much important in a criminal trial. If we talk about the accused person, then accused is at the center of the trial and he also has certain rights. Under certain circumstances, he may choose to remain silent. You already are aware that Article 20, Article 21, 22 of the Constitution of India itself are oriented in a way that they give sort of directions to us that look, this is the manner in which the rights of an arrested person may be protected. This is the procedure. If a person is arrested, he or she has to be produced within 24 hours of his arrest before a competent magistrate. The idea is that there should not be any possibility of abuse of human rights, abuse of the basic freedoms of that particular person. So that is the idea of the criminal justice system, and with that purpose in mind, these particular provisions have been provided in the Constitution of India, which find further detailment in the Code of Criminal Procedure Act of year 1973. So now friends, if we talk about the punishment aspect, then you would know that we have a provision of rigorous punishment. We have a provision for death sentence, which is the ultimate penalty. We also have a provision for solitary confinement, and these are the different types. And mainly, fine always accompanies the final sentence when it is handed out by a court of law. Then it is in the nature of imprisonment, or then it is usually accompanied by a sum of money, which is in the form of a fine. Okay, so fine is imposed if the person is found guilty. All right. So that is the outcome, and this is contained in section 53 very clearly. So if you look at, there are different categories set. There also used to be one punishment, that is transportation of life, but now that punishment has been removed from the ambit of the criminal justice system. Now friends, if we talk about the prisons, then prisons are a place which are always are in the limelight. And especially if we look at the present COVID scenario, then you must be aware that when the COVID pandemic started to spread its wing all over the place, the Punjab government released a lot of under trials and a lot of prisoners on parole. And the idea was that prisons in our country, it is well known, are very much overcrowded. So there have been several reports in the past. So you need to look at the report of Amnesty International. You may also look at the reports of Human Rights Watch on the prisons, the condition of prisons in the country India, and of year 2008, 2009, and even very recently. So you just need to visit the websites of these agencies and you will get to know. Even if you look at official prison statistics of the Ministry of Home Affairs, it is available on their website. Please do take out time and you may visit these websites and these sources. And if you start consulting these sources, it will become very easy for you to really understand that and look at the condition of the jails or the prisons in our country. Now we have different types of jails, and these jails are categorized keeping in mind the age and and the and the special character of the particular offender, the person who is convicted, the convicted persons. Now, the children are obviously not put along with hardened criminals. Those aspects we will have an occasion to deal when we look at the aspects of jail manuals. But to start with, we must remember that at the time of independence, it was a big problem, and we had a person by the name of Dr. Reckless coming from United Nations. In fact, on the request of Jawaharlal Nehru, he was sent to India, and it's a very important and anecdotal history, and it is part of the Law Commission reports also. And if you start reading the literature on the prison system of the country, you would get to know that this episode and this event is well recorded. Now, this person was charged and he made a careful examination. He visited several places in the country, and he gave the opinion that prisons have to be organized in the country on certain lines, and he gave certain recommendations. So we will have occasion to look at those recommendations. Then there have been several committees which have been appointed. Now, Mullah committee is one of the very important committees which also we'll be looking at in detail, the scope of that committee. Along with that, there have been several Law Commission reports which have tried to focus on the aspects of prisons, prison reforms, the kind of punishments which are being met. So you must understand that there is a lot of interlinkage between these aspects, and as we go along, please keep at the back of your mind the constitutional principles which we discussed, and which basically always remain at the heart of the understanding. So whether we are looking at the Mullah Committee report, whether we are looking at the Law Commission report, whether we are looking at the Justice Malimat Committee report which came out in year 2003, whether we came out at the Justice J.S. Verma Committee report, or any report having any relevance with any aspect of the criminal justice administration which we try to understand, you must never forget the foundational basis of the criminal structure which we have just talked about in our interaction today, and that you must understand that there is a stepwise gradation of offences in our system. So the more serious the offence, the harsher the crime. If the crime is less serious, then obviously the law contemplates, as it has been envisaged in our nation, that it should be mild. The punishment should be mild. So this is the general framework on which we would like to proceed to understand the Probation of Offenders Act, the jail manuals, the Prisons Act, and also the Police Act is important. So the police force was established during, it's a colonial product. Police in India is a colonial outcome, because when British rule was there, and the governance question was there. So then police was also sought to be organized, and Lord Cornwallis undertook a lot of reforms and steps in this regard to organize the police structure of India. So though we have already discussed that part, but still you must keep that in mind, and whenever we get to refer back to that, you must keep that understanding before you, and the understanding as we go along will become more and more clear if we keep these aspects in mind. So my suggestion to you, as always, is that please do not forget to read newspaper daily, because the role of the police is always in the question. Even if you look at the scenario of COVID-19 pandemic, you would see that the manner in which the police is enforcing the lockdown, the curfew restrictions on the people is always in the news, and why it is in news, because after all, police has this strong arm. Nobody likes to be whacked by lathi. No one likes it, and why would a citizen like it? And no one also likes to be told to observe and behave in a certain way. However, for the larger good, one has to comply with the basic rules and regulations in a society, and that is what the whole ordered society we talk about. So the enforcement of the peace is not an easy thing, and police is always being questioned in this regard. You may see that sometimes if it uses excessive force, then there are questions raised, and you must understand and you must try to have a holistic outlook of the whole issue. You may also see images on the screen where police is distributing rations to the needy people. Police is also trying to ensure that the helpful person who need immediate help, they are taken to the hospital. So the duties are police is performing multifaceted duties in these difficult times. So you must also imagine the contemplation of law and the enforcement of the law as it would happen under emergencies. Now, friends, as just a quick look, or we would like to take a quick small discussion also on the aspects of the Epidemic Act of 1897, and you are already aware that harsh punishment has now been imposed on anyone who would use violence against the frontline warriors, okay, and especially on doctors and nurses. So in this pandemic scenario, and this ordinance was passed, and it prescribes very harsh punishment, excessively up to extending up to 7 years in prison, and almost a fine of rupees 5 lakh is imposed. So that is the step which the government has taken by bringing out an ordinance. Now, ordinance, as you are already well aware, is something which is brought on in an emergency situation when the parliament is actually not in session, and there is an emergency, and there is a need to bring out certain law or piece of law to tackle with a certain urgent matter. So that is there already in place, and with this we have taken care of the general organization of the criminal justice system in the country. We could also talk about the role which is performed by each of these agencies. We also focused on some specific provisions which are invoked whenever an offence is committed. We also took note of the objective of the law or a criminal justice administration in the society. Several cases are also there which we will have occasion to delve in detail in our upcoming meetings. We have already dealt with cases like Sheila Barse. We have on custodial torture, we have dealt with the case of Sunil Batra. We have dealt with case of D.K. Vasu versus State of West Bengal, which gave detailed guidelines, that it's a Supreme Court judgment, to the police to be observed to make sure that the criminal justice system runs smoothly. And so these are all very important judgments. So along with that, we will have occasion to look at even more judgments. So we also had occasion to talk about the Shatrughan Chauhan case, very important case with respect to the punishments which is being rendered out, and also the role of government with regard to mercy petitions in the case of the Vinder Pal Singh Bhullar versus state. So you must understand that all these important cases will come into sharp focus as we keep talking about our discussions on the prison system. And prison system is only just an extension of the whole process of the criminal trial. Once the trial ends and someone is convicted, that person has to be put into a prison, and in that prison he or she will undergo a certain imprisonment. But please remember one thing, that even a prisoner is not bereft of every of very basic liberty. He also retains some sense of liberty, and there is a particular discussion which we will have about the prisoner's rights. We would also like to talk about the prison reforms, the particular committees, what was the object of the committees, what did they recommend. So with this hope, I request you to keep a track of the developments, latest developments, how the police is performing, and also try to read little bit about the prison reforms and the rights of the prisons in our country. So with that, I take your leave for the day, and I hope you enjoyed our interaction for the day. Thank you so much.